Calling the matter of Sara Ramshaw for hearing.
In 2014-15, I was the principal investigator for a UK Arts and Humanities Research Council project entitled Into the Key of Law, transposing musical improvisation in the case of child protection in Northern Ireland. So this project united Northern Irish family law with a new and emerging field of studies called critical studies in improvisation, which views improvisation not just as a musical, but as a social practice, one that involves creative decision-making, risk-taking, trust, and collaboration. What emerged from this project was the importance of listening, not only as it applies to musical improvisation, but also law and justice, especially in places such as this, the courtroom. So improvisatory practices teach us how to listen, really listen, to the singularity of the situation and its relationship to context and the surrounding circumstances. Listening in this setting is not just about a sense of hearing. Rather, it is a multi-sensory and collaboratively enacted by a broad range of human and non-human actors. My research explores the social and dialogic nature of improvisation and how active listening skills, one of the core elements of the most achieved musical improvisation, may reveal different forms of social relations. In May 2015, as part of this project, my research team and I organized an interdisciplinary symposium at Queen's University Belfast, where I was then based. This event brought together academic and non-academic participants, both local and international, from musical, legal, and social work backgrounds, to explore the improvised creativity that is at the heart of legal decision-making, specifically as it applies to the area of child protection law. Over the 2 days, panel discussions led by local judges, social workers, and other professionals explored the current improvisatory practices in the legal domain. These panels highlighted the importance of improvisation, not only as a technical ability, but also as one that demands careful listening and empathy to the multiple parties involved in such delicate and complex cases. Of particular interest and significance to participants and audience members were comments made by one Northern Irish family law judge, Patricia Smith, who spoke passionately about the importance of attentive judicial listening. The barrister on this panel, a woman who the following year would become the first High Court judge ever in Northern Ireland, provided an example of how Judge Smith's attentive judicial listening played itself out in practice in relation to, in the case she's speaking about, a vulnerable mother. And I'm going to play this clip. It's about 4.5 minutes, so that you can hear their voices for yourself.
Effectively. Now, one of the points that our speaker this morning talked about was the importance of people feeling that they have been heard.
Yes, okay.
And my own experience is that if people genuinely feel they've been listened to, that the judge has understood their point, that the judge has given it proper consideration, even if they lose, they can deal with it.
Yes.
Because they believe they've been listened to.
That's right.
And it is a key task for any judge to not just listen, but to convey the fact to the person that they have been listened to.
Right.
And in my own experience in the family court, I think it is of an absolute priority that the vulnerable parents are made to feel that they matter, that they are treated with dignity and respect. And I consciously speak directly to parents, for example. I do it deliberately and consciously so that they understand. And very often, some of the vulnerable people who find their way into the court, they've never been listened to by anyone. They've been treated like a piece of dirt by authorities everywhere all their lives.
All the time.
And as a judge, I make it a priority that in my court they will not feel like that.
That's beautiful.
It's hard work.
I know.
I don't say that by way of jest. What I mean is
No.
there are so many facets to what I have to achieve. It's not just
Exactly.
about getting the right decision, and that's hard enough in a lot of cases, but communicating with the people involved and with the social workers, for example, if I don't agree with them, that they understand I respect their position and that I understand their decision making, even if I have disagreed with it. So,
Can I give you an
That's deep
example?
listening.
An example of what Judge Smith has said, just as somebody who's appeared in front of her in relation to an adoption case. So we have freeing for adoption on our as our law, which is adoption without parental consent. So if you are a parent and you're found to be inadequate, your child can be adopted. Right? Doesn't apply across the world like that, but it does apply here. So anyway, yeah. My client was an extremely vulnerable woman, and I had no case to make, really. She was going to lose her children. She wasn't the woman who had got over the issues that I talked about, like addictions and partner and such like. However, I contested the case and called the lady to give evidence, and Judge Smith heard the case and gave a judgment where she spoke directly to my client. And the bright light in that case actually was that the lady, if she could cope with the issue, could have some contact with the children down the line. All right, so they weren't totally airbrushed out, so she would have some what we call post-adoption contact. But at the hearing, notwithstanding the way the judgment was very carefully put to this lady, the lady had a very bad reaction to it, understandably, because she's losing 2 children. And I thought to myself, right, she's never going to pick up on her contact, and that's really a tragedy because she's a young woman. Now, if I can fly the flag for social services on this point, I met the social worker about 2 months later in relation to this case, and she kept an interest in that lady. I said to her, she had a very bad reaction. I hope you go and talk to her and she keeps up the contact. The social worker did. And she said, you know what, she's totally calmed down. She understands this now. She heard what the judge said. She's going to give this a go, and she is going to get contact. But the big thing that she also said was that she was heard in the court. She had a very bad background. She had no mother figure herself. And the big factor for her was, well, she'd had her say, she understood the decision, and she was going to go for the contact. So that was crucial.
So these comments by Judge Smith and the now Madam Justice Keegan have helped me think more deeply and practically about what attentive listening might look or sound like in the legal setting, or what might actually do acoustic justice sound like. In law, listening with respect, openness, and responsiveness is not always an easy task. Attentive or deep listening in law, as in music, requires an ethical commitment and responsibility to, as well as an interaction with, all that surrounds us. Persons, the environment, and the sounds of daily life. It demands attunement, not only to the singularity of the situation, but also to the context and community within which it is performed. Deep listening is an improvisatory practice developed by the late Pauline Oliveras, who was actually the woman in green who was interacting with the judge during that clip. According to Pauline, deep listening forces individuals, including judges, to stay present, that is, remain in the moment and focus on the decisions at hand. It also teaches people to be aware of others and their surroundings and to take risks, trusting themselves that they know the right answers, but also understanding that such decision-making requires extensive knowledge and skill and much practice to get it right. From deep listening, according to Oliveras, springs compassion and understanding. Improvised music is very much in tune with attentive or deep listening. It both relies on certain laws of music to be recognized as improvisation, yet at the same time it transgresses these laws in a gesture towards the unknown other, to voices and sounds typically silenced in music and society. Attentive listening in improvised music thus does not just sound the auditory. It forces us to think otherwise in terms of our social relationships and our customary frameworks of assumption. As such, just listening, or the justice that flows from attentive listening, is extremely important to law and judicial practice. As Fischlin, Heble, and Lipsitch note, to quote, the ability to listen deeply, critically, attentively, creatively, curiously, and intensely to the others around you is a profoundly sensitive register of a broader set of commitments to social responsibility and cooperation. In tune with Judge Smith's comments we heard earlier, attentive judicial listening involves not only listening to what litigants are saying, but letting them know that they have been heard. This is important for a variety of reasons, particularly in cases outside the experiences of the privileged, white, heterosexual male judges, still the norm, I assume, in Australia as it is in other places in the Commonwealth system. In such cases, judges must listen for different facts and explore perhaps often subtle behaviors or unpredictable behaviors. This requires reflection as to how judges listen and what they listen for, perhaps even developing new listening skills. New listening skills, just last minute, please. How judges, as the ultimate decision makers and directors of the jury, undertake this task is crucial to determining the extent to which just outcomes will be achieved and identify ways to hone the skill of judicial listening within the legal framework. Any study of judicial listening, that is how judges read a case, approach and perceive its facts, and listen to the parties involved. It's essential because when done well, attentive listening can minimize the litigants' feelings of alienation and dispowerment, assisting them in moving on with their lives. It can also have a significant impact on how cases are processed, the sensitivity in which they are approached, the issues that are brought to the fore, as well as the ultimate outcomes. Improving judicial listening may enhance the experience of justice for litigants, reducing feelings of not being heard, and offering a wider societal benefit by making judges' approaches to such cases more observant, open, and responsive. This open listening attitude, as an openness towards other voices and the voices of others, creates a space for justice to happen. Listening is always a listening with and to otherness. Not entirely intuitive, attentive, open, and listening must be learned and honed. Improvised musical practices thus speak not only to music, but to other realms as well, such as law and justice. Judges accordingly have much to learn from improvising musicians and from other artists, like many of you in the room, who are interested in improvisatory practices. Thinking about listening as a listening with can teach us much about responsibility and hope, about how to adapt to change, especially in times of crisis and despair. Just listening promotes multivocality and being with difference, rather than a falling back on the often destructive dominant narratives. It teaches us how and when to listen and encourages co-creative, improvisatory solutions to societal and legal problems. It encourages us to find a way out of no way, or in the words of Sun Ra, to sound the other side of nowhere. And all of these, I think, are desperately needed if we are ever going to truly achieve acoustic justice. Thank you.